Good afternoon, Year 12, and welcome back to another video. Basically, the last one on the Supreme Court, which is really good for us because it means that we are kind of at the end, for the moment, of new stuff. I'm not thinking or planning to do anything new now for a few weeks, probably until at least after May half term. And the reason for this is because I want to give you a chance to catch up. I want to give you a chance to do some extra revision, give yourself chances to have a think about the stuff we've been talking about, and also we can do some recap essays and recap tasks that will help us in the future when we're coming up to exam time. So this, as I said, this is kind of the last lesson on the US Supreme Court. It's the last lesson on new information that you need to know. And so basically, I would be taking notes and using it as that kind of frame of reference of the end of the Supreme Court and also the US-UK civil rights comparison that you will need to be able to do. So I would set out my notes with US and UK on two sides of a table like this. And I would basically just note all this stuff down, put it in note form, making sure you know what it means, make sure you know what the significance of these things are, and if you need to look up anything that doesn't make sense in the future, then use this time to do that in that after you've watched the video. So for the US, if we're talking about general points to do with civil rights, in the US, civil rights appear in written form in the Constitution, in the Bill of Rights itself, in the 15th Amendment, in the 24th Amendment, in the 26th Amendment, which is particularly important because it's about voting rights, and also in the 19th Amendment, which is particularly important because it removes the bias between genders. Civil rights also appears in laws in Congress in the Voting Rights Act of 1965, the Americans with Disabilities Act of 1990, and the Lilly Ledbetter Fair Pay Act, which was 2009. What you need to remember with all of these is civil rights does not just mean the struggle that many African Americans have had against the authorities in America to gain the vote. It also means civil rights for everybody to do with gaining equality and freedom of information, even if you're disabled or have a different sexuality and stuff like that. In the UK, I'll come back to the last point in a second. In the UK, people have relied on A.V. Dicey in the absence of a codified constitution, and they've quoted the 3 points, or 3 pillars of liberty. We will do these when we do liberalism anyway, so you should become particularly familiar with these and when we go further on in the course. But these were the only real protection of civil rights up until 1998. In 1998, this all changed with the Human Rights Act. The Human Rights Act added the freedom of expression, the freedom of religion, the right to bear a fair trial. Right to bear arms. So used to saying that now. The right to a fair trial and the right to life in British law. However, these rights are not entrenched at all. This was made clear when, following the 2015 election, the Conservative government announced plans to replace the Human Rights Act with the British Bill of Rights instead. And this could have been achieved with a simple majority in both houses of Parliament, but it wasn't. But basically it means the Human Rights Act is open to change if a government decides they want to change it. So therefore, in the United States, civil rights enjoy more of a protection and are consequently more secure than they are in the UK, which is probably converse to what you were thinking about the way that we could compare UK and US civil rights based on civil rights histories. Right, there's a lot of information in this slide, but it's relatively simple. So we're going to talk about the effectiveness of the protection of rights on this slide. So in the US, it's possible to find examples where rights have not been particularly effectively protected. The passage of post-Civil War amendments did not end racial discrimination. For example, we've already talked about Plessy versus Ferguson and how the Supreme Court allowed separate but equal, which is not accurately or effectively protecting civil rights because none of the actual implementations of separate but equal were ever equal. And this was, as we know, repealed through Brown versus Board of Education when the Supreme Court looked into whether it was equal or not and ruled on the side of Brown in saying that she should be allowed to go to a white school because the provision for African Americans in her city were not great at all. They were awful. Even after the 24th Amendment, which was the right to vote in 1964, discrimination in voter registration still existed, especially in the South. We've talked about pre-registration and all that kind of stuff, and how even though after 1964 it was still something that we saw very relatively often. The gay and lesbian community would not have said the 1996 Defence of Marriage protected their marriage status, because being married as a gay couple in America was actually illegal at this time. There were also those who regard the protection of a woman's rights to choose abortion as having led to a decrease in the protection of the rights of the unborn child. That's an interesting one, because whatever side of the argument that you sit on there, you can argue that civil rights are not protected for the other side. And so that's a kind of ethical argument that is not solvable through civil rights, really. There's also been significant issues since the 11th of September 2001 attacks, 9/11, on the balance of protecting rights and liberties, because the new rules on the detention of immigrants, the new search powers of homes and businesses, as well as telephone, email and financial records through the USA Patriot Act, tilted the balance too far in the terms of national security for people. They believed that their civil rights were being infringed because of all these new rights through the USA Patriot Act. However, if you put all this stuff together, the rights of those with disabilities and those from racial minorities and women are more effectively protected than they were 50 years ago. So you can kind of look at it as a whole and not just look at it in separate acts, and look at it and say, actually, this has been a positive change. In the UK, the protection of rights can be achieved by the judiciary through a number of ways. The use of judicial review, usually through ultra vires, also upholding the Human Rights Act, and declaring and regarding common law and judicial inquiries are all effective ways for the judiciary to kind of protect civil rights in Britain. Parliament also plays a part as well. They pass legislation such as the Equal Pay Act in 1970, the Sex Discrimination Act in 1975, the Race Relations Act of 1976, the Disability Discrimination Act in 1995, and the Freedom of Information Act in 2000. However, in 2010, to make all of this a lot easier in Britain, the Equality Act effectively consolidated all of these anti-discrimination practices into one law. Again, in Britain, though, there has been similar questions as America about the violation of civil rights, especially after the London bombings in 2005. So the new law to allow police to detain terror suspects for up to 90 days without charge, and the new offences surrounding glorifying terrorism and hate speech have caused questions to be asked. And there's been many kind of cases and challenges to these. One that I particularly like to kind of bring up when I'm talking about hate speech and the infringement of freedom of speech in this country is the man in Scotland who taught his dog to Nazi salute, and he was effectively charged under the Hate Speech Act. He lost his job, he lost all sorts of benefits that he had due to this, and he tried to fight this conviction in court, and said that actually the Hate Speech Act is just a violation of freedom of speech, and he's actually not been successful, as far as I remember, with that challenge. And so that shows in Britain that we have a real issue with what freedom of speech is and what hate speech, whereas in America you can get away with saying quite a lot of things under the freedom of speech because they effectively protect that. In both the USA and the UK, though, there is an overriding cultural belief in the principle of rule of law, and this emphasises the supremacy of the law, it stresses the protection of individual rights from arbitrary interference from government officials, and it reinforces respect for the law and adherence to the court's enforcement of it. So even in both countries, we have this kind of cultural kind of slant towards the law and to understanding the law, and kind of we almost trust government officials and lawmakers to have our best interests at heart. It's not for everyone, but some people do. There's also been a massive role of pressure groups in the protection of rights. This is good for your pressure groups work on a whole, because you can talk about some of these pressure groups and how they've had an impact, but also it's good for the civil rights section as well. So we'll start in the US as usual. It was the NAACP, the National Association for the Advancement of Coloured People, that provided the legal backing for Brown versus the Board of Education of Topeka in 1954. The NAACP provided lots and lots of money, but also lots and lots of lawyers that were very expensive, but also very hard to find to be on your side in the civil rights cases. And they provided this background for many of the cases because they genuinely had the backing of enough people to do it, but also they believed that this cause was worth fighting for and this money was worth spending. Also, many of the Supreme Court's most civil rights cases have involved sponsorship by other pressure groups as well as the NAACP. In landmark decisions regarding issues such as abortion, gun control, and affirmative action, interests on groups from both sides of the case may be influential in submitting arguments to the court. And these groups can submit these arguments. They're called amicus briefs. It means friends of the court. And they could submit these arguments to try and sway the court in either way. For example, in two affirmative action cases in 2003, Gratz versus Bollinger and Grutter versus Bollinger, the University of Michigan's admission programs deluged the courts with these amicus curiae, friends of the court's beliefs, to influence the decision. And similarly, the McDonald City of Chicago case had 33 amicus briefs submitted to try and sway the court in either way. One of the most influential pressure groups in America for civil rights was the ACLU. It still is. It has 750,000 members and 200 attorneys and officers throughout the US. It joined the NAACP in challenging school segregation in the 1950s. It was also involved in the Roe v. Wade 1973 abortion case, and it brought a case against Attorney General Reno in 1997, resulting in the Supreme Court striking down the 1996 Communications Decency Act due to the broad banning of indecent content on the internet. They also have defended such groups as American Nazis, the Ku Klux Klan, and the Nation of Islam in freedom of speech issues. The ACLU fights for basically the underdog in these cases because they don't do it on principle. They do it, well, no, that's actually what they do it on. They do it based on principle, not based on beliefs. So they will basically argue for anyone that shares the same principles as them, even if their beliefs are different. That's why they've supported the Ku Klux Klan, but also supported the NAACP in the past. They are fighting on the basis of principles, usually freedom of speech, but also lots of other civil rights principles as well. In the UK, due to the rise in the UK's use of the judicial review in the last 30 years, pressure groups have been encouraged to focus their campaigning in the courts, and this has led to conflicts between pressure groups and their beneficiaries in the UK court as well. There's one big example that I like to point you towards, and that's the Asher's Bakery case in 2006. So Colin MacArthur was prosecuted under the Equality Act for sexual orientation, for refusing to produce a cake for Gareth Lee bearing the slogan "Support Gay Marriage." MacArthur claimed his firm could not produce a cake as it would be contrary to his religious beliefs. MacArthur's case was taken up by the Christian Institute, and Mr. Lee's case was supported by many gay rights groups as well as those supporting same-sex marriage. And when the courts found against Mr. MacArthur, the prominent gay rights campaigner Peter Tatchell came out in support of Mr. MacArthur's rights. So you can see here there's a whole kind of swamp, a mire of issues that can happen when pressure groups go to court, because even people that share the same beliefs can have different principles. Peter Tatchell came out and supported Mr. MacArthur's rights because he said that his Christian beliefs should not be changed by this Equality Act. And he said that even though the Equality Act and the fact that he refused to do this cake was against gay civil rights, it's not against his freedom of speech, and therefore it's violating Mr. MacArthur's rights. So similar to the ACLU in the US, the UK has another civil rights group called Liberty. And this campaigned for the rights of women in the 1930s and the rights of anti-Vietnam War protesters in the 1970s, and it was an early supporter of gay rights. They've also played a prominent role in the challenging of anti-terrorist legislation since 2005. So again, Liberty is like the ACLU in that it protests based on principle. It also campaigns on issues such as the use of torture and extradition, as well as the rights of asylum seekers, refugee children, and the members of the UK Armed Forces, and it's recently been much more prominent in campaigning against modern slavery. All of these groups have a significant impact on civil rights, as you can see, through the courts and through supporting some of these things, but their actual extent of their impact is widely debated. So as a follow-up to this presentation, I would like you to look up the ACLU, look up Liberty, and I would like you to think about how prominent they've been and their impact on the civil rights in both America and the UK. And I would like you to talk to me about the impact that these pressure groups have had based on what you know and what you've read about them. If you could submit to me basically a half a page, just a conclusion on the effectiveness of these pressure groups, that would be absolutely fantastic, because I would know that you're still engaging with the videos, but also I'd know your views on this, and I'd be able to kind of correlate an idea of where we are with up to this kind of video and whether we've got a lot of people that are falling behind or not. So that would be lovely. If you get the chance to do that, I would be immensely pleased. Aside from that, Year 12, that's all I've got to say to you today. So I hope that you find this video useful. I hope you find it quite interesting. And as I said, we've now come to the end of the Supreme Court, so you can kind of box off that part of your notes. We will come back to it and we will do some recap knowledge over the next couple of weeks. But as of right now, that is the end of kind of course-based learning that we're going to do at the moment. I hope you find this useful. Please let me know if you have any problems. Chat to me on Teams or send me an email. But apart from that, Year 12, stay safe and I will see you later.